The live show brought to you by Indian Association of Greater Chicago. My name is Ranjit. We are here today with the prominent attorney Greg Siskind to discuss the latest updates on visa bulletin, frequently asked questions on adjustment of status or green card filing and other immigration matters. You can call the numbers displayed on the Facebook page to ask a question. We'll start taking calls in about 20 minutes. Before starting the call, I would like to give a brief introduction about IAGC. The Indian Association of Greater Chicago is a nonprofit organization formed in 2016 with the primary purpose to preserve, maintain, and perpetuate the heritage of people of Indian origin and to serve cultural and educational needs of Indian community in the Greater Chicago area. Currently, the organization is in Greater Chicago and serving the community whenever there is a need. Hi, Greg. Good evening.
Hello.
Greg is one of the prominent attorneys having decades of experience in immigration matters. Could you please introduce yourself and then we can start with the questions?
Sure. I'm Greg Siskind. I'm an immigration lawyer. I've been practicing for about 30 years. I am in Memphis, Tennessee. And my practice is mostly business and employment immigration, although our firm does everything. And over the years, I've developed a niche practice with physician immigration, although I'm involved in lots of matters beyond that.
Thanks, Greg. Thanks. Before I start the show, I would like to repeat the disclaimer. Please note that this show is not intended to provide any legal advice. It is general in nature and it is only for informational purposes. Please use the information at your own risk. We are not responsible for your actions. Hi, Greg. It has been a roller coaster ride all this week with visa bulletin surprises and everything. So yeah. I just want to start with basic questions.
Sure.
What are the final action dates and filing dates, and how and when these USCIS decide which dates to use, and is there any standard practice?
Yeah, so it's a bit of a mystery as far as what goes on behind the scenes, and even if you were just paying attention on social media this week, a lot of us were caught by surprise. We weren't caught by surprise that in the numbers there was going to be a big rollover of numbers, and I've been talking about that for a couple of months since these bans went into effect. I had heard earlier in the summer that there were going to be about 100,000 family numbers and about 25,000 or so employment numbers that were going to roll over to the other side. So basically, family numbers being converted to employment-based green card numbers starting October 1st, and employment numbers being converted to family numbers on October 1st. So what we didn't know was, I mean, there were some unknowns there. So we didn't know if the White House was going to get involved in kind of play games with the visa bulletin. We saw that happen in July, where we should have seen family-based Mexico numbers become current because a lot of them are in the United States and could have used those numbers up. But that didn't happen. And we saw on the other hand DV numbers where they became current because people in the United States were going to be eligible for all those numbers. So it didn't really make a lot of sense. And we knew that must have been some kind of political intervention. We didn't know if that was going to happen, where they were going to try and prevent people from applying that might have been eligible. So that was going to play out in two different ways. One was, were the dates going to advance significantly as should have happened on there, and then whether they would, the filing date charts, this USCIS with the State Department, whether they could be generous on the filing date charts, even if the numbers didn't advance a whole lot. So in the morning, when the bulletin was released, the final action dates were not particularly impressive on there. It moved up like, I think it moved like 2 months, I think, on the EB2 numbers, and I'm trying to remember how much it moved up, but not very much, and not that much on EB3. The filing date charts moved up a lot, which is what we're here talking about today. What we didn't know in the morning was what USCIS was going to do. They have been probably most of the time in the Trump years turning down, and the State Department the State Department develops that chart, and then USCIS has the option to announce whether they're going to accept it for a given month or not. So I wasn't particularly optimistic in the morning when it came out, and then that lack of optimism was validated because USCIS then published on their website that they were only going to use the final action dates. So that was disappointing. And then voila, like an hour or two later, they flipped the charts and said, no, we're going to take the filing date charts, which is going to result in a lot of people filing adjustment of status applications this year. We don't know why that happened. We don't know whether what was going on, whether it was a snafu and they were supposed to take somebody posted the wrong chart all along, whether some pressure was put on them, whether they were concerned about a lawsuit being filed, which probably would have been filed because, as I said, with all these numbers rolling over, the fact that the final action date charts didn't move very much was suspicious. So we don't know what the reason why they picked it or don't pick it. What we do know is that we have a fairly major advancement, 2 years in EB2, 5 years in EB3, and we have the possibility of downgrading for a lot of people, which means that even people in EB2 who are not current may be able to move their applications into EB3 and take advantage of that January 1st, 2015 date. And if they have an application earlier than that, even if they're in EB2, they may be able to file. Not everybody. National interest waivers, for example, can't take advantage of that. And also EB1 moved almost to being current for India with the filing date chart to September 1st, 2020. So that's really good news as well for those folks who are filing in that category. I know there's a lot of EB1Cs, intracompany transfers, and there's also a lot of Indians in the extraordinary ability category. So good news for them there.
Yeah, I know this is a huge chunk of number, but then still the country cap removal is something we all need. Mm-hmm. I know you're always supportive on Twitter about, and you are voicing your opinion on it. So what do you think that this still should be focused on? Still, people should advocate on country cap removal?
Yes, and I hope that once people get their green cards, they don't forget their friends and that are still stuck in these backlogs. But this is really not. I mean, what's happening is helpful in terms of reducing backlogs, but it's really not going to make a huge difference in the grand scheme of things as far as waiting times for a lot of people, especially people that are. I mean, it will move. It will move the lines up somewhat, but when you look at the inventories, this is maybe going to clear out 25% of the inventory of people that are backlogged right now. It's hard to say. On there's about 350,000 I-140s that were filed for Indians between in EB2 between in 2010 and 2020, and I think about 67,000 EB3. And then there's some from 2009 that we don't know how many of those were still left unadjudicated at this point. So if you just add those two numbers up and you think that only about 100,000 are rolling over, there's still a lot of people who are going to be impacted. Plus, the numbers going forward are the backlog is going to build up over time again, just because a high percentage of the skilled workers coming into the U.S., much higher than 7%, are from India. So this backlog is only going to blow up again when the economy is doing well. So I'm still urging people that not to forget. First of all, there's the principle of it as well. Regardless of whether this is providing relief to a lot, it's just discrimination and nationality. My view has been the same all along. Nationality discrimination needs to end in the family categories and in the employment categories. And it's needed anyway, not just on principle, but it's going to be needed for a lot of these people that are going to be waiting for years and years if they don't have it. So I'm still hopeful that there will be political support for that. The good thing is, if we get if the election goes for Joe Biden, he does have a provision in his immigration plan where he says he'd like to end nationality discrimination in the quotas. So I'm hopeful that that's something that will come to pass.
Sure. Thanks a lot for your support of removing the country cap. That's any discrimination is a discrimination. We all know that, and your support means a lot, especially at the national level. Now, I would like to ask a couple of questions about. So, does this mean that filing dates are only to get an EAD and final action dates are for green card? So, what happens down the line when the dates retrogress and they come back? So,
So basically the filing date chart means that you can file an adjustment of status, and that chart is a projection or a forecast of where the numbers will be on September 30th, 2021. That's how they come up with that. That's the concept is when they invented this thing 6 years ago, that they can the statute. You can't just allow early adjustments for everybody because it's in the statute and Congress has to pass a law to change that. But the way 245A reads, it says a visa number has to be available. So they changed their way of viewing that language and said, well, if you're in the fiscal year and we know that by the end of the fiscal year the numbers will be available, then we can take the view that a number is available because that we've started that you're in that it's available in that year. That's sort of the interpretation that they use to come up with that. So what that means is that they can accept applications for people before these dates in anticipation that they should finish within the fiscal year. The visa number should be available by the end of the fiscal year for people that are filing under the filing chart. So that's that's sort of the way it works. As far as EADs and all that, once you are filing for adjustment of status, you're permanently benefiting from that, even if, for example, the numbers start to retrogress, which could happen because of this downgrading that I mentioned earlier. That if a lot of the EB2s decide that they want to file by downgrading their petitions and file in the EB3 category, it's very possible that the January 1st, 2015 date will retrogress, and they may not approve everybody in EB3 that has a priority date before that because they just have a lot more applications in that category after all the downgrading happens. But so that what that would mean is that the people that filed for adjustment of status may not, with the later dates in EB3, might not get their green card at the end of September 30th, 2021, at the end of the new fiscal year, but they would still get the benefits of an adjustment of status application, and that includes first and foremost, there's a concept of portability. Once you've had adjustment applications pending for 6 months, you can change jobs to any job that's the same or similar to the occupation that was the basis for the green card. What that means is that you can change employers relatively easily without having to do new H1B petitions, for example, and you also have the ability in a lot of cases to start your own businesses, which I know there's a lot of entrepreneurs out there who would love that opportunity and haven't been able to because they've been stuck in these green card quotas. So just getting your adjustment application filed is going to make a huge difference for a lot of people. It also means that family members can get employment authorization documents without having, then you don't have to stress out of what happens with the H4 EAD rule. Kids can also lock in their ages on an adjustment application. Once they file that adjustment application, they are protected under the Child Status Protection Act. So that's a big benefit for children who will be able to ultimately get their green cards in the end, and they will get work cards as well tied to that. So there's a whole lot of benefits that come, and I tell people it's sort of like a lower tier version of a green card, an adjustment application. It's obviously not the same thing, but you get a lot of the benefits of permanent residency, including the ability to work for who you want to work for, much easier travel without, you don't have to get visa stamps. So all that will come. What we don't know is if there's a lot of downgrading that happens. What I anticipate is that we're going to see the November visa bulletin show the dates in the EB3 category may become unavailable. EB2 may actually advance, where if they don't get nearly as many applications as they thought, or they think a lot of people have downgraded, they may move the EB2 petitions back up a little. So there'll be a rebalancing to some extent, but my advice is get your application filed in the month of October. Don't mess around, and the earlier the better. There is some precedent for them to retrogress in the middle of a month, but they'll probably get sued if they do that. So I'm hopeful that they'll do the smart thing and just take all the applications in October and not mess around with retrogressing. But you might want to the extent you can, get your paperwork into your lawyers quickly.
Yeah, thanks for that. Greg, other question, the follow-up question is, do you think this downgrade should be considered by the people? What are the steps they have to take, make sure they are not missing up?
Yeah, so downgrading there's a lot of confusion around it. Most immigration lawyers have had to do a lot of educating of ourselves this week, because we really haven't seen this since in 7 years, I think, was the last time we saw anything like this with it was involved China at that time, where EB3 China, I think, had moved faster than EB2 China. I think that was were those two categories. But anyway, so and the rules changed a little bit, actually making it a little bit easier in 2017 with the high skilled worker regulation. But basically, if you downgrade correctly, you don't give up your rights to later try for EB2 if the numbers move around. So that's important that it be done correctly. And the main thing there is to make sure you don't withdraw or revoke the initial I-140 when you file the new I-140. You'll keep your priority date, but you would lose the ability to adjust under EB2 later on if you do that, which you would obviously want to keep your options open. So, basically what you're doing here is filing a brand new I-140, but based on the old perm, which you're allowed to do. You can file more than one I-140 based on the same perm. And sometimes people file initially I-140, I-140s in both EB2 and EB3 based on the same perm. It's unusual, but it's permitted. So that's that's one thing to keep in mind. Premium processing is not available, we believe, for these new petitions. So it's a problem if premium processing happens to be needed. Most of the time, it's not going to probably make that big of a difference, because you can concurrently file an adjustment in a new I-140. But it may be an issue. Downgrading is not a possibility as well if you have changed employers, which a lot of people will have changed employers during the last several years, and you don't have a new perm for your new employer. So I had, for example, somebody who contacted me yesterday that was in that situation, and I had a conversation with them. I was like, what's your relationship with your old employer? If they would be willing to hire you back, then you can file and they haven't revoked that old I-140, then you can file, and so we're gonna do an I-140 and an adjustment for that old employer, which they're willing to go back to, if they can get an adjustment application filed. So that's how they're fixing that problem. But that's not going to be sometimes that's not going to be a possibility. And unfortunately, if you have to file a new perm, there's probably not going to be enough time to take advantage of this. So that could also keep the numbers down somewhat as far as how many people actually downgrade, or a certain number of people are not in a position to be able to file a new I-140 that quickly.
Yeah, follow-up question again. So what happens, let's say, if the old employer has withdrawn the I-140 when the employee left? So what's the procedure? And other question is, let's say the employer wants to downgrade and do whatever he can, but then do the employee has to go back and work for them, or they can just work for the current one?
That's an interesting question, because what you're attesting to with an immigrant visa petition by the employer is that the person is willing to work for the employer when the adjustment's approved. So it is possible to, just as long as there's agreement that you're going to go back to work for that employer, that you wouldn't actually have to move. I think it increases the odds a little bit about whether USCIS might view it as being a genuine job opportunity on there. If the employer, is able to, if the employer doesn't have somebody in that position now, for example, I just see it as potentially opening up more possibilities for requests for evidence if the person isn't going to work for them right away. But technically speaking, I don't think it's a requirement.
How about the withdrawal of I-140 thing? What happens when
that's more concerning, because I think that would invalidate the perm petition if the I-140 has been withdrawn. The priority date may be fine on there based on that old I-140. The 2017 rule says that if you had an I-140 approved and it's been approved for 180 days, it locks in your priority date, even if the employer revokes. After that. So you still have that old priority date if it's been revoked, but you don't have the valid perm, and that's what you need to do a new I-140 to downgrade. That's the problem with that. So if the employer is withdrawn, I think you're probably gonna have a problem.
But a lot of news going around that I'm not sure, no one knows anything, because these rules are kind of a gray area where there is no regulation written.
Well, there is a regulation from 2017 regarding the locking in the dates, and there is a regulation regarding perms being invalidated if there's no I-140, if the I-140 has been withdrawn on there. So I think that's going to be, the good news is a lot of employers don't withdraw I-140s because there's no benefit. It's different than the H1B. The H1B, if an employer doesn't withdraw the H1B, they're liable to pay back wages. But if they just leave the I-140 alone, there's no penalty for the employer to do that. So it's more to be spiteful than, or maybe they think that that they are required by law to do it, but they're not. So I think the tendency for a lot of employers, when they ask me what I should do, what they should do with an I-140 for an employee's left, I usually just tell them it's like, you should be able to just leave it alone on there. It's not going to really hurt you, and you never know, and you sort of close the door for potentially bringing an employee back. So that I-140, that's the thing. If they keep that I-140 pending and an employee comes back, they save a lot of money of not having to start a green card application again. So there's an incentive for the employer to keep that I-140 if there's any possibility that that employee might come back at some point.
Sounds good. But then there are mixed responses from attorneys saying that, once I-140 is filed, the perm is valid for life. You can just, even if it's withdrawn, you can just go ahead and just file an I-140. This is something that's going around?
Yeah, but for downgrading purposes, it still has to be the same offer. The job offer still has to be available. Let me reserve on that and just say that that the I-140, I don't think that that's correct, but I've been wrong in the past on various issues. It's the kind of thing I probably would research. But I don't believe that that a perm that doesn't have an associated, because there's a requirement that you have to file an I-140 within 6 months of a perm being approved, and if there's no I-140 associated anymore with that perm application, I'm not sure that it's still valid.
Okay, let's see what's going
to happen. So that one is ask your attorney to do a memo for you researching it.
Yeah, that's what.
Don't let them give you an off-the-cuff answer. Tell them that you want a memo with citations.
We would like you to, do some research and advise us on this. That would be
I've started an FAQ on this downgrading stuff. So that's a question that I have not had yet. I'm going to actually take a note to put that in about with the initial employer withdrew the I-140.
Yes, yes. Really appreciate if
So
you can
you're
do
the
that.
you're the first person to ask me that.
Yeah, this would be really helpful because a lot of things happening in the last few days and everyone is swamped with questions, emails and all. We want to know what for sure that could be done because no one wants to risk it.
Yeah.
Now going back to the other question, now because there would be a lot of downgrades, would be thousands, maybe 100,000 or 200,000. Do you think USCIS will give hard time making it tough for people to downgrade so that they can restrict whatever they can?
Well, I think that the regulations are on your side here. The question is whether USCIS, whether they want the downgrades or not. I think that they should hopefully have been correctly advised that by doing what they just did without putting anything out on this issue, they're inviting 100,000 or more people to try and downgrade. So I would tend to believe that they're going to follow the rules because it's a little ridiculous, the amount of work that's going to be involved with refunding all this money and processing and sending all these applications back and all that is probably almost as much work as just adjudicating them. And they don't get the money. I'm relatively optimistic that we're going to see them be reasonable on this. With that said, I mean, there's one lawyer group I'm in, there's been a discussion and one lawyer a couple of months ago on a downgrade had a notice of intent to deny, and she basically followed the rules and has been fighting with USCIS, although that case is not over yet. At least in that one anecdote, there was an example of the USCIS examiner giving somebody a hard time on this issue. I think, though, that that's not that unusual for USCIS to not be that conversant on a relatively obscure subject, which is the case of downgrading. It's about to become a lot less obscure for USCIS examiners, but it hasn't been a big, upgrading was the big thing a couple of years ago. That's why there's so many people in EB2 right now for India, which is several years ago everybody was asking us to how they can upgrade their petitions, but downgrading hasn't been in USCIS at this point. There's not a lot of information they put out there. There's a regulation that makes it pretty clear that you can have more than one I-140 associated with the same labor certification. So that's a long way to say I think they'll do the right thing and accept all these applications without trouble. Whether that proves to be reality or not, we'll find out in a couple of weeks. But I think most people should probably. I think the rules are such that most people that file, if they give trouble, there's going to be litigation, and I think USCIS would lose on that. So it's worth filing because I think people will win in the end on that issue.
So yeah, I believe the same. It's kind of once in a lifetime opportunity, and we think everyone should use it, and it's worth giving a try.
Yeah.
The other question is, at what point of time do employee has to go to the employer once the adjustment is filed? Let's say he's working with a different employer.
So if the person's working with a different employer, then they're not going to, well, first of all, if it's just a regular petition, at that point they can file the adjustment on their own if they're already in EB3. If we're talking about a downgrade, and it's a new employer, then you have to basically ask the questions like, I don't have the perm is going to be the problem there. They don't have a valid perm. Starting a perm process, you're talking about 6 to 10 months if everything's going smoothly on that. So you're probably not going to be able to take advantage of downgrading if you're with a new employer that hasn't filed an I-140 for you already. Hopefully for a lot of people, they have new petitions already, new I-140s that were already filed for new employers, or at least have a perm process that was started for a new employer. But a lot of people probably thought their dates were so far off that they didn't really worry that much about starting a new perm process, and that concerns me a little bit. Is that people didn't know this was going to be coming and that there was going to be a 5-year jump that was only going to be available for 1 month window that you had to use it. So, for those that switched employers, but moved far enough along in the process, they'll be okay. For people that haven't filed anything with their new employer and they don't have a new petition in EB3, then I think they're probably not going to be able to take advantage.
So let's say the old employer filed the adjustment. Someone has to go back to them and work for them at some point of time?
So yeah, so the question on that is it can't be totally just as a favor by the prior employer. There has to be employment that's still available. They're still going to have to attest that there is a job opportunity that's available to you. You don't have to go work for them immediately. Under the rules, it's basically the law says you have to be, there has to be a position that becomes when the green card is approved, that they agree to come and work for you. So, think of it this way: you may have somebody who is going through a labor certification that's outside the United States, and that person can't they can't actually start work for that employer until a visa number is available, and that may be 5-10 years. So an employer in that case has to basically the person still at the end of that process has to show, like 8-10 years later, that job still remains available. But they weren't required to work for that employer during that whole time. And it's the same way if you're filing within the United States. Just because you can work for that employer, perhaps on an H1B, doesn't mean you must work for that employer for the green card petition to be valid. So that's a long way to say that you should be okay. I think if you don't work for that employer initially, the main issue I might be concerned about is USCIS maybe questioning whether there's really still a job there or not. So they could RFE on that issue. And there's a little bit of a risk there that an examiner might look at it suspiciously if you don't, but it's not technically a requirement that you have to work for them before the process actually finishes.
So even after getting the EAD, you don't have to go and work for that employer?
No, but I would say that after you get the green card, if you don't go and work for that employer, there could definitely be a fraud finding. Don't forget as well that you still have portability in adjustment. So you're not required to work after the adjustment's been pending for 6 months, and that's probably how long it's going to take for an EAD anyway, that you benefit from portability rules as well. So you've got that on your side as well. I wouldn't worry that much right now about that issue, unless we start to see, some decisions coming down that seem to contradict that. But for right now, I think we're okay on that.
One thing at a time.
Yeah.
Yeah. So follow-up question again here. So what happens, let's say, for the people who are filing the I-485 now, let's say one of the applicant, let's say because of this COVID and separation and everything, the consulates being closed, family members are being stuck in India. Mm-hmm. So how is there any possibility for them to include the wife or children stuck outside the country?
So I'm adding that to my FAQ as well. Family stuck abroad. Yes. That's a good question. Hopefully that has been somewhat reduced since more of these exemptions became available, but we know a lot of people are still stuck in that situation. That is a problem because if retrogression happens and they're still stuck outside the country, then they're not entitled to, you have to have a number available. And we've seen this before. I've seen this in my own practice with nurses, where we had nurses that were working in the United States, and then their family members were staying abroad. Their numbers became available, but for 1 month, but the family still hadn't arrived in the United States. They were going to consular process after the green card. They were going to consular process after the nurses in the United States adjusted, and then the numbers retrogressed, and the family members got stuck abroad on there. So that happened to quite a number of nurses around the U.S. during that. Something very similar. So I know from that past history that can create a long-term separation issue. And that would be a reason why I would probably keep the underlying H1B valid, even after you have an adjustment application, if you have family in that situation, so that they can eventually get here. Now, if they get here, if the numbers have retrogressed or become unavailable, I think there's still going to potentially be a problem, but there may be I mean, it's possible somebody at that point could say they either would abandon the adjustment application and stay on the H1B, or the family members could be able, maybe the spouse could convert to an H1B instead of an H4. You know, sort of like you just deal with one problem at a time here. But that is potentially going to be a problem if the numbers retrogress. You know, and I don't know how that one gets resolved yet.
But the thing is, here, can a person abroad be included in the petition at all when you are
You have to
filing?
be you have to be physically in the United States to file an
that's a
adjustment application.
So and one other question, let's say the adjustment is pending. Can someone travel out of country, you know, or is there any regulation stopping them?
So it depends on your visa status. If you're on H1B, there are pretty good rules out there for being able to travel either on an H1B or an advanced parole document, which you'll get with the adjustment application. The advanced parole application, I mean, the advanced parole document is nice because if consulates are shut down, you can still travel in and out with the advanced parole document, which USCIS gives you in the United States.
But that's only when you get EAD approval, right? Let's say if the EAD approval
is separate, not yet, they're separate petitions.
Separate.
So the I-131 is the advanced parole, and the I-765 is the employment authorization document. Typically, I mean, they sometimes do combo documents, but they oftentimes will approve an I-131 on its own, and it's just a piece of paper with basically your picture embedded in the paper instead of a card. But but you don't need to have the EAD for that. A lot of times because the EAD has been included in the cost of the adjustment application as well as the advanced parole, that has been, it hasn't been that much of an issue because they'll do the EAD kind of as an automatic thing with the combo card. That, by the way, is supposed to, and this is another thing we didn't talk about yet, which is fees are all supposed to be going up on October 2nd.
Yes.
So if people are able to file this to arrive on October 1st, they'll save money. I-140 fees are actually going down though, but adjustment fees are
not
going
much.
up. Yeah, not a lot, but the adjustment fees are going up quite a bit.
Yes,
true. Because and they're going to be charging now separately for work cards and travel documents, which they have
for each applicant.
And family members, right? Family member fee. It's going to cost people a lot more money to adjust because of all these USCIS new fees. That might not happen though. This is the other thing you have to watch and pay attention in immigration news. There's a lawsuit that had its arguments. I think they had them yesterday or Friday rather. And the judge in that case, they're seeking to block the fee increase from going into effect on October 2nd. So we don't know yet for sure that these fees are going up on October 2nd. What I can tell you is if you submit your applications with the incorrect filing fees, they will ship your application back and you might miss your window. So just make sure that when that you're pretty clear about what the actual fee is when you send it. You won't get into trouble if the judge, if the judge issues an order after, if it was correct when USCIS got it, let's say the judge doesn't issue this order by October 2nd, issues it like a few days later, and you sent in the fee that was the new fee for October 2nd, you'll be okay in that respect. But if the judge issues an order and USCIS suddenly changes their fees, it's going to be instantaneous. And if you file and you just didn't know about the judge's order, you could have a problem. So that's just something to pay attention to that lawsuit.
Will the refund if the injection is after, let's say, October 2nd?
Could it happen after that date?
No, let's say a court wants to stop it, let's say on October 5th. Will the USCIS refund?
Will they refund? No.
Yeah.
Well, I don't know. I don't think they will. I don't know if they know how to give change.
True, true. So yeah, another question here. How long does it take for the advance parole to kick in? So because without advance parole, let's say someone is traveling for emergency for out of country, how does it work? I mean, they can enter on H1B if they have H1B, but then are there any restrictions?
No, I mean, it's a pretty liberal process. If you enter either on the if you enter on advanced parole, it doesn't invalidate the H1B. If you enter on the H1B, it doesn't invalidate the adjustment of status application. You can't, you have to be in the United States to file an advanced parole application. And that's, and then, you know, that could be an issue. But there's a decent amount of flexibility for the H1Bs. It's not the case, by the way. And L1s, I think, also have, it's similar to that. If you're in other categories, though, that doesn't, and you leave the United States without that parole document in hand, you'll be considered to have abandoned your green card. So it's really important to make sure that before you travel, that you
do not travel before you have advance parole in hand.
Right. Generally speaking, it's a good idea to have that advanced parole in hand unless you have this H1B exception. And even then, I usually suggest clients check in with their lawyers just to make sure that the travel is meets the parameters of the regulation as far as that goes. So usually that's okay.
Yeah. So another follow-up question here. So let's say the adjustment of status is pending and the H1B or H4 EAD or the work permit expired. Can they work? Do you suggest keeping both, you know, until you get a EAD?
Yeah, you can have more than one EAD. You can have more than one adjustment. You can have more than one H1B. I mean, there's not a limit of one on there. But what I would suggest is that, you know, given the EAD, H4 EAD, the precariousness of its future, I wouldn't rely on that EAD when you have another EAD that you're eligible for. So I would file for the second one if you're eligible for it, and then you don't have to worry about what happens if that one goes away. Hopefully, EAD processing times will improve. They've been abysmal for the last year. There's been a couple of lawsuits that have been filed on that. Very common theme of just about everything is in litigation right now. There was a problem with H4 with 765s being approved and then the cards not being issued. That got a lawsuit in the my friend Rob Cohen in Ohio won that suit. And USCIS now is under an order when a 765 is approved to issue a card within 7 days. The 765s have been taking forever, and there's now another suit that's challenging that part of it, the fact that they're taking so long on those applications. I think they're actually publishing on their processing times for one of the 765 categories, like a 2 to 3 year adjudication time, which is just, you know, that's just basically sticking the middle finger at people. I'd say it's yeah. I mean, this is something that probably shouldn't take longer than it takes to produce like a driver's license. I mean, it's not. There's not that much. There shouldn't be very much that goes in. Maybe 10 minutes of an examiner's time to figuring out whether somebody qualifies for that EAD or not. So the fact that it's taking so long, something's very broken in that process, and I'm not really sure what their excuse is for that. They haven't really been offering one yet.
So one cannot work when the H1B expired and the adjustment of status is pending.
If the H is expired, well, you're talking about if the H1B is expired.
Yes, and AOS is pending.
Yeah, you can't work until you have an employment card.
Yeah, that's so clear.
You need to have that. If you work without that employment card, it's going to be considered unauthorized, and that could potentially cause the adjustment application to be denied.
Yeah, another great challenge here is convincing the employers to downgrade. I know it's hard, especially for public listed companies or large MNCs.
Yeah,
they don't encourage this kind of thing.
I've had several hospitals actually where I've got like calls from 4 different hospitals from doctors that convinced the hospitals to downgrade them to EB3, and these hospitals were calling. It's like, how can our doctor be eligible in this category? It only requires a bachelor's degree, and it's like, You just have to trust me. It's a thing, and they're not wrong, and you can do this. And so, that's the. But there have been employers that are just. I don't think there's any animosity to helping out their employees, but there's some confusion about whether this is a thing or not. So they're just being educated, and just tell them to. If your employer gives you any pushback on that, tell them, can you please call your immigration lawyer? And that should do the trick, because most immigration lawyers in the last 48 hours have figured this out.
Yes, true. And we would also appreciate if you can write some, I know you have written a blog or article about it. If you can explain or expand it, a lot of employers can show that, and, being a notorious attorney, maybe that would help people to convince.
Feel free to cite me. Yeah, I'm going to expand a little bit more on that document, and I already know a lot of immigration lawyers. There's actually, though, something that's better than my document, which lawyers will have access to, and you can just see this here. This is the 2013 memo that USCIS put out, not USCIS, that AILA put out. It was a practice advisory for the immigration bar. It's a technical document. That's why, it's for immigration lawyers on precisely what you need to do in order for this to happen. But an employer that looks at this document will know that that this is not just sort of a made-up concept that's been around for a while.
Yeah, last question before I jump into caller questions. This is a burning question here. I-485 filed under current filing dates will not freeze the child's age under the CSPA if kids are aging out. So what's your comment on that? Will it freeze if the ages of child with the filing date?
I think it depends if they're depending on that's a good question. If they're depending on the filing date chart and not the final action chart, you know what? That's a question. That's an Ari Sauer question. We have one of the foremost experts in the country in our firm on Child Status Protection Act issues. Ari Sauer.
I think there is also a lawsuit going on this situation. We know that, but the main problem is we had lots of questions, especially with the kids are aging out in few months, but they are filing I-485 under the filing dates. So they are still confused.
That's a question I will promise you I will get you the answer on that. I have a feeling it's going to be Ari's going to tell me that.
Because Cyrus Mehta has tweeted.
Why it might not be. Here's the thing. The CSPA is from like 20 years ago. The filing date charts are from 6 years ago. So that concept was not actually a known concept when they wrote the CSPA. That's why I think what Ari's going to tell me, I think it's locked in when they say a visa number has to be available.
That's final action date then.
Well, but not necessarily on there, because they have to say a visa number is available in order to be able to file an adjustment in the first place. That's sort of this legal fiction that they used when they came up with this concept of the filing date charts. So the fact that you filed an adjustment application, USCIS has to indicate that a visa number is available. Now, keep this in mind. There's nothing in there that says that they have to allocate the visas month by month as the year is going on. You can just say there's a big pot of visas that are available. What they've traditionally done is that they basically allocate a certain number each month, and then they move the charts up. So what if they're saying that by the end of the fiscal year, this is where they anticipate being, it means that they have enough visas on October 1st that are available. They just won't be able to actually allocate all those visas until the end of the year. That's how they came up with this whole concept, to allow people to file the adjustment applications based on the filing date chart. So I haven't, I'll have to ask Ari on this. My argument, off the cuff argument, would be that the CSPA is not affected by which chart you file under, because in either chart, the argument can be made that a visa number is available, and you file it because by definition, when you file an adjustment application, there has to be a visa immediately available. That's in 245A that says that. And if the number is immediately available, then it locks the date in. So I think that's the answer. but I'll try and add that to my FAQ.
Yeah, sure. I explicitly asked this question because people have been going crazy, especially Cyrus Smith. I have tweeted on this saying that, it will not be protected. Kids are not protected.
Yeah, Cyrus is pretty damn smart, but I want to talk to, but Ari thinks about CSPA more than anybody I know. He's written a software app for it too, so I know that he probably has to make sure that he has all the contingencies in there. I'm going to ask him, and I'm actually writing a book with him right now, and I know that, so I talk to him almost every day. But I want to see what he has to say.
Sounds good. It would be great. And the last question before I take the call, everyone is now going crazy for birth certificates, medicals, all the documents, and no one knows that they may get it on time. Do you think are these mandatory now, or
medicals you may be able to submit late? That is I believe that can be RFE'd if it's not available, and the reason for that is I believe that because adjustment applications, sometimes medicals are only valid for a year, and the adjustment applications often take well over a year to adjudicate. That people were in the position where they had to do another medical exam in order to be able to complete processing. My understanding is that that in most instances now you can get a request for evidence and submit it at that point. You're not going to adjust without a medical exam, but you may not have to submit that at the beginning. Double check with the lawyer regarding your the procedures for where you're filing, but that may be something that you that you're okay on.
Okay, thanks for answering that question. We just wanted to know the petition won't be rejected if there is any document that's not mandatory is being produced. So people are going crazy to get all the documents. Okay.
Well, look, it's a good idea to get all the documents in and not have to stress over it. But that one, talk to your lawyer about, because you may be okay on the medicals.
Okay, let's take the first caller here. Number ending 7470. Number ending 7470. You are on air. You can ask your question. Five 712097470. That's the number. Hello. Okay, let's take the next call. Next call, Kira, number ending 1524. 1524. Number ending 1524. Mitapalli 1524, number ending. Okay. Next call, Praveen, ending 1821. Oh, it's weird. Okay, looks like there's a technical problem. Meanwhile, I have some questions that I would like to ask. So now the public charge, it's being again got into place now, the public charge. What is this? What is the effect on the stimulus recipients, who got payments? Do you think this is going to affect them?
No, that's an issue that was discussed at the time, and it's basically a tax refund. So it's not based on need, and that's what would trigger public charge issues. Everybody got, I'm presuming you're just talking about people who just got a check in the mail without actually applying for anything. Are we talking about the $1,200 checks?
Who got payments? That's what. So a lot of people had that in mind that,
that's not a public benefit.
Okay. And other thing now the farm, so the public people are going crazy, going around on a lot of social media things. One part that's confusing for a lot of people is the English language proficiency. So these people are going crazy that do we need to write IELTS, TOEFL, or is it not needed when the degree of instruction is already English?
Yeah, if you have the information, you can include it if you have TOEFL scores and all that, and answer that. If you have that, I mean, if you happen to have that in there, it's a positive factor if you speak English. So it's a, I mean, obviously you guys do, but you might as well list it in there. The main, it's one of those confusing things, and and as well. But I would go through and answer basically everything that you think applies to you. I'm not too worried about anybody in an EB category getting slammed on a public charge issue, because you guys are all working. That's the whole point of this on here. So you're not likely to be impacted. Where you're going to have a problem more is if you screw up the form than what you say than the fact that you're a public charge. It's going to be mainly, if they say that you left blanks, or you left out sections of the form that needed to be completed. So I would try and be as complete as possible. I wouldn't worry that much about, for any of you, that you're not that you're actually going to not be able to adjust because of public charge issues. That's probably not going to be your problem.
Okay. Another call, we had this question offline, but I just wanted to ask it on the air. What's your take on next year's movement? Will the employment-based category going to get more family-based unused green cards, since the ban is until the December?
Well, I mean, it all depends on what happens in the presidential election. If Biden wins and Trump leaves office, you have to say both things now. That the president, the orders expire. That the whole thing that caused this were these bans, and the bans expire on December 30th. So Trump will probably extend the bans until the very last day, January 20th. So you're going to have basically about a quarter, well, actually October, November, December, January. So about a third of the fiscal year will have been impacted on there. The question will be at that point, because Biden will probably invalidate the executive order within an hour of him being inaugurated. What's going to happen is he's going to go to the White House, and he's going to have all these new executive orders he's going to sign that are basically going to invalidate all of Trump's, because Trump loved executive orders. He has 1 million of them out there on all kinds of things other than immigration. So Biden will strike those down. Then what will happen is whether the question is going to be whether the State Department can catch up or not over the course of the year. There's been some recent litigation that says they should be actually working on and issuing visas, that they are not getting a permission slip to not work on these because of these bans. They only are barring entries. They're not barring visas. There's more litigation that's coming on this. Our firm just was involved in a litigation on K-1 visas, which doesn't affect any of you guys. Probably not, but that's another one where we're making an argument. They're not issuing K visas to people in countries that have travel bans. And we're making that same argument that these bans all come from a section of the law that says that they can bar entries, but not visas. That's all relevant here, because if they are working on visas, then it's not going to be that. If they work on visas over the next couple of months, it's not going to be that hard for them to catch up once the entries are eligible again. So that's really unclear. I would imagine that there'll be a lot of political pressure on the State Department to try and catch up, because so many of these family people have been waiting, patiently since April to get their visas. And my guess is that they will, and I know a lot of people at the State Department have been disgusted with these proclamations, even though they work for the president. They can't say it publicly. Privately, they have, and I know they're going to be, a lot of them are going to be itching to catch up and be normal again. So I wouldn't count on the rollover is the answer for next year. There may be a little bit, but I don't think we're going to see anything remotely close to what we saw this year. On the other hand, if Trump wins, there might be a big rollover again. But on the other hand, if he wins, he's got a lot of stuff in store for skilled workers that are going to be not so great anyway. So I wouldn't be rooting for him to win, because they're rooting for this ban to continue. There's a whole lot of nasty stuff that he has in mind to make a lot of H1Bs potentially fall out of status and have to leave the country on there. So that's don't wish for a Trump win because you think the numbers are going to advance faster if he comes in. I don't think that that's going to be the result you want.
We need a permanent solution.
Yeah, and we already know his position on 386, for example, or more green card numbers. He's against more green card numbers generally, and he's against 386 for whatever reason, because he got Rick Scott to kill that bill at the last second, and I'm not seeing that changing. So that's yeah, I don't think a Trump win would be in any way good for good for skilled workers.
Yeah, we are already almost an hour. I'll take some questions. I think we are on. Praveen ending 1821. Praveen ending 1821. Can you ask your question?
Yeah. Can you guys hear me?
Yes, please go ahead.
Okay. Yeah. So my first question is this priority date forward movement. Is this based upon what USCIS sees as a rollover or spillover numbers till the end of the September, or are these anticipated based on November of 2021?
The numbers that they used in the filing date chart are based on where they see movement, where they see the inventory being used up over the course of the year. You know, I don't know how much they considered downgrading when my guess is they didn't consider downgrading at all in that. But in terms of how these numbers came about, the final action date chart is based on where they see numbers over the next month being available. Now, one thing we saw minor movement there. I don't know if Charlie Oppenheim, the guy who writes the State Department Visa Bulletin, considered all these numbers rolling over in that, because technically speaking, until 11:59 on September 30th, he doesn't really know how many numbers will roll over on there, because there's it's up to the end of the fiscal year. We're not quite there yet. So he might have been a little bit more conservative, and I think I posted on Twitter that we might see some significant advancement in the final action date chart in the November 2020 visa bulletin, not the 2021. But on the other hand, he has a pretty good idea, more broadly speaking. It's more of it's definitely more of a forecast than an exact science, where he thinks they're going to be on September 30th, 2021. And that's how, and the filing date chart is where he would see where the numbers would go. What I think he hasn't done is factored in downgrading and just assume that based on the current inventory that everybody stayed in their current categories. And he knows about downgrading and upgrading. This is not this is something that they know is a possibility, and trust me, they know, because the State Department and USCIS were both involved in these regulations that got issued. These were issues that were discussed at the time, so they know, and they wanted that to be a possibility. So with that said, I don't know, after the next fiscal year what kind of advancement we're going to be seeing. I think that they will look again and see, and one thing we haven't mentioned, by the way, is coronavirus has had an impact as well on USCIS processing domestically for adjustment of status applications. They haven't approved nearly as many as they thought. So there's some numbers as well that are rolling over on the US, based on USCIS processing here. So I think it's a little early at this point to say where the numbers are going to be in fiscal year. I guess in October of next year, that starts fiscal year 2022. I think your question was about where numbers are going to be at that point. Maybe I was wrong in interpreting, but I think it's still pretty early to say.
Yeah. Next question from the caller 8276. I think funny 8276. You are on air.
Hey, hi. Yeah.
Yeah. Go ahead.
Yeah. So I have a situation like I'm trying to downgrade from EB2 to EB3, and my company is merging with another company starting next year, Jan 1st, 2021. Right. So if I file my I140 and EB3 and 485, so will this be a problem when the company merges?
Yeah. So it's definitely something that needs to be discussed with the immigration lawyer. There is as a concept in law called successor in interest, where in some cases the I-140 can be taken over by another employer. Most of the time, a perm can survive a merger if the new employer succeeds to basically agrees to take on all the immigration liabilities and takes over the I-140. But sometimes a merger is not really a merger, it's more of an asset sale, and not everything is transferring. Most of the time it will work though, and a new I-140 that gets filed will still work because of the successor in interest concept. The only thing is that it could confuse the Immigration Service, for example, if it's a new employer ID number that's associated with it. And part of this process with the I-140 is you have to show that the employer succeeds to the interest of the old employer so that they can legally pick up the perm application, and it's considered to be a perm for the same employer. So it's complicated, but there are immigration rules that are designed for this situation, and it depends on how the deal is structured. But your immigration lawyer should be able to research that and ask questions and be able to give you an exact answer.
Thanks. Chandra, another call, Chandra, 6275 ending, 6275. Yeah. Please go ahead.
Yeah, thank you. Can you hear me?
Yes, please.
Can you hear me?
Yes, yes.
Okay. Hey, Greg, I have a question, and my previous employer has 140 approved and EB2, my current date came in. But if he is not ready to file 485 for me, can I go ahead and file without the supplemental J and wait for an RFE and go for the current job up to 284J? Is there a way that can I work through that way?
Yeah, so you're talking about filing with the supplement J form, but you don't get that benefit of portability, which I think is what you're talking about for an adjustment filing, unless you've had unless the adjustment has been pending for 6 months.
Now, I think his question is, can he self-file if employer is not supporting?
Self-file, no. And this is an I-1, not based on perm. This is a employer-driven. If this was the only categories you can self-file, and an EB3 downgrade is going to require an employer's petition. The only categories you can file an I-140 on your own are in a national interest waiver situation, in EB2 or EB1 extraordinary ability. But those are about it for self-filing. In theory, you could, yeah, and you also have to have a perm, and the employer actually technically owns the perm, not the employee. So I think you got to get your employer on board. Why would your employer not be interested, by the way?
There are a lot of reasons. Some employers, when you leave them, when you don't have that, when you leave them abruptly without telling them, they may be mad and they won't do it probably, whatever the reason.
One thing I can tell you that might change the mind of some employers, the regulations require the employer to pick up the legal expenses and the filing fees for, well, there's no filing fees, but the legal expenses for a perm application. The I-140 and adjustment of status are USCIS processes. USCIS doesn't regulate who has to pay those fees. So while I think it's the right thing to do for employers to pay those costs, if that's what's causing them not to file this because they don't want to pay, you can keep that in your back pocket potentially and say, I'll go out, if I go out and find my own lawyer, who will do this, will you sign the I-140? It's not, in that case, it's a question, they have to find some other reason why they wouldn't want to do it. But that maybe some employers might be thinking that this is going to be an expensive process for them, and it doesn't, it doesn't have to be. If that's what's causing this to be them to be the problem here, that's something you can hopefully work out.
And moreover, large employers have a lot of hierarchy where you ask them but you don't get any response. Yeah, that's
here's the thing. You're not the only. If it's a large organization, they're getting this request from a lot of people.
True.
And they've just all probably gotten alerts from their immigration lawyers over the weekend or over the next couple of days. They're going to be hearing about this. So I don't think, I think that they will be expecting to hear from you. And I know some people are actually some of these employers are actually proactively reaching out to their immigration lawyers to ask them about it, knowing that it's probably going to be coming. And in some cases, the responsible employers are as well as alerting their employees who may not really understand what just happened, that they are going to proceed with doing this downgrade for them on there. So, you know, I would, but for large employers, if your employer if you haven't heard anything from I would definitely reach out affirmatively to your employer. I would just be surprised if they haven't heard anything about it by the time you do.
Yeah, next caller, let's take 7172, ending 7172. Please be quick. We have a lot of callers, so I just want to run through this one. Yeah.
Yeah, Ranjit, can you hear me?
Yes, please go ahead.
Hello? Yeah.
Yes,
so I have quick questions. So yeah, generally, you know, how long does it take to receive an EAD? I understand I-485 stays there for years, but is the receipt sufficient, or the EAD on an average, how long does it take to just send the EAD back, approval EAD?
I would probably say 5 or 6 months is probably what you're going to end up seeing on this, based on you know, on averages. Some of these service centers are slower than others, but that's probably where they're going to be at by the time you get yours.
Yeah. The next caller, Prashant 9448. Please be quick.
Yes, I just have a very quick question. My date for the adjustment of status is current again, although the final action date is not current. So can I add my spouse to the application?
Yes, if you're eligible to file an adjustment of status and it sounds like you had an adjustment pending and it retrogressed. Is that what the issue was?
No, he says my filing date is current. Can I add my family members in the I-485?
Yeah, you can add your family members in the I-485. I thought you were talking about a situation where you like maybe got married after or something like that, and your dates had retrogressed, which is something we see from time to time. But you don't think that was what the question was? Even
let's say that's the case. What do you think? Can something be added?
Yeah. So if the dates have moved, you know, if the dates have moved up enough, and you know you have a spouse, yes, you can add them. But you can add them initially. You can always have your spouse and minor children can always apply for adjustment with you if you're eligible and they're here.
What if it's in the middle of process and you got married? Can we add in the middle?
Depends if the numbers are still available at that point. If the numbers have retrogressed after the marriage, you know, and they're not available anymore, then you're going to have to wait on a date to become current.
How about this case? You know, let's say the spouse is from India and the other spouse is from Nepal, let's assume. So when they file it, how does it work? There is something called chargeability.
Yeah, so if you are ever in that situation, what a lot of people have gotten out of the per country nightmare by having a spouse of a different nationality, and it's called cross chargeability, and you can claim to be, even if you're not, you know, don't have a passport or anything like that, you can claim your spouse's nationality for purposes of being able to operate in that quota. So that sometimes is a one way to get around this.
Got it. Next question, Srinivas Rao, be quick, 0624 ending.
Yeah.
Yeah, go ahead.
Right. So question is like, you know, my priority date is 2013 on EB2, and if I downgrade to EB3, and as I hear, like, you know, starting of the conversion, like, you know, we can have a multiple 485 and multiple for I140, right?
Yes.
So later on, let's assume EB2 got, like, you know, current for, like, you know, the thing. So would I able to file 485 on that category?
He's asking about kind of interfiling. Could you please explain about the interfiling thing?
Yeah, so you can file inner filing is notifying USCIS that you have another I-140 and you want to switch the basis for a current adjustment application to be based on that in order to be able to adjudicate more quickly. So let's say you file an EB3 based I-485, and then the dates move around a bunch and you have another I-140 that is now all of a sudden that they're current in that category and it's no longer moving so quickly in EB3. You already have that because you've already downgraded, but you already have the other I-140. And it's just a matter of notifying USCIS that you wish to adjudicate based on the other I-140, not on the new one. Then you also have the ability, or you could potentially just file a second. Sometimes can be a little bit difficult to get USCIS to actually handle the request. It's not a question of whether you're entitled to it or not. Sometimes it's just difficult to get them to do something. And some people have actually just chosen to file a new adjustment application based on another petition that they, when they're eligible for that, and have a second adjustment application pending, but it's normally not necessary to do that. But it's possible to have two adjustment applications pending. Where we see that happen more often is where maybe you have two spouses and each spouse has their own I-140 for a different job, and they file adjustment applications for the whole family. And then you have two adjustment applications, one as a spouse and one as the principal. And the advantage of that is if something happens on one because maybe they say that the employer went out of business or was something improper about it and they deny the adjustment application, you have the other one as a backup. So that's what sometimes people do that.
Okay, we only have 10 minutes. I'll take a couple of callers. Ramesh ending 9519. Ramesh ending 9519.
Yeah.
Go ahead, please.
Hey, yeah, I'm there. Hey, I have one quick question. The biggest question I have is who is supposed to have a 485J, which is a supplement? See, I have my priority date with my current employer. I haven't changed my employer. So do I still need to have a supplement J form, or else can I go ahead and use only a 485 original form?
The supplement J form, I think you still do it even if you haven't changed employers, just to verify the ongoing employment. So I think that form still needs to be in there. I sound like I'm hesitating a little bit. I'm sort of thinking through what our paralegals do on here, because the supplement J obviously is a critical form when there is a change in employment, but I think it's actually, you have to have it in there anyway for an employment-based case. So 100% positive, but I believe you do.
Okay, next caller, Karthik ending 5744. Karthik ending 5744.
Hi, Greg. Thanks for taking this call.
No
I have
problem.
I-140 approved with the ex-employer. The priority date is November 2013.
Mm-hmm.
With my current employer, my firm is approved and they've filed I-140 in EB2.
Okay.
So should I run that I-140 EB2 in parallel and some I-140 for EB3?
Yeah, if you have an I-140, if you have a perm approved with the new employer, you're going to pick up the priority date from the first employer without having to get them involved. So what you want is to have your new employer file an I-140 downgrade for you based on the approved perm, and then you'll just have to document that the priority date, you have the priority date from the original I-140 as the basis for the claiming eligibility to adjust. So you shouldn't need, if I understood your question correctly, you shouldn't need to get your earlier employer involved.
No, what he's asking was his EB2 I-140 is pending. Now he's asking, do I have to file another EB3 I-140 or just ask them to downgrade?
Yeah, you'd still file a new I-140 based on EB3, and then you would have but it would be based on that approved perm. The key is that the perm was approved. It doesn't matter that the EB2 I-140 is pending. It matters that the perm that you're basing the new I-140, EB3 I-140, that perm has already been approved. So the answer is the same on there. That you
can we ask USCIS to downgrade the pending I-140, because that's anyways will be in premium.
Well, why do you want it?
Faster.
What's the advantage?
Maybe because it's already, they have the original labor in that, and that makes the things faster.
Yeah, but if they, first of all, I don't think it'd be that easy to do that. And second of all, you would be losing out on the ability to later adjust.
Okay, got it. So better to file EB3.
Yeah, I mean, there's really not the premium processing, I don't think gives you much of an advantage because you're filing the adjustment already.
Yeah, true. Concurrent filing.
It's not really going to get you, there's not going to be a big tangible benefit that you're going to get out of it. So I think and also, I don't think you're going to be able to premium process. Well, you could convert the other case to premium processing if you wanted to, because the original labor certification is part of that case. But I think I would still just file an I-140, regular filed I-140 with the adjustment application.
That's better.
With the new one, and leave the other one alone.
True. The next caller, Vamshi ending 6082. Vamshi ending 6082. Vamshi ending 6082, you are on the air. Okay, next one. Vaidya ending 6166. Vaidya ending 6166. Srutesh.
Yeah, hi.
Go ahead.
Yeah. Yeah, I have a quick question. That my spouse has been in India and she got COVID infected. So at max, she can come. I mean, estimated date is she can return by October 25th. So is there any way that until I can keep all the documents ready, and once it come, we can submit by October 29th or something like that?
Yeah, I mean, you should be okay if you can get all these. If she's going to be in the U.S. on October 25th, I think that's the day you said. You should be okay to file everything on that date. There's a slight risk that if there's an announcement of a retrogression before October 25th, that it could adversely affect you. I don't anticipate that's happening, but not unheard of. That was what caused the whole visa gate mess in 2007. That was what kind of started.
Does that happen? They can do it in between the months?
Well, so they tried, and there was a big blow up, a lot of protests and things like that, and Congress got involved, and then they ended up reaching a settlement, and they said that everybody could apply for the month. They gave a little window that everybody could apply for. That had their applications rejected when they tried to change the visa bulletin after it had been issued. So I think you'll be okay as long as you get this application filed before the month's completed. And I think it would be, while there could be an argument made to file for yourself first and then add your spouse after that, logistically, it's a lot easier to have everybody in one application.
Okay. The next caller, number ending 4702. Be quick, we only have a couple of minutes. 4702.
Yeah, hi. Yeah, my EB3 is approved with my previous employer, and recently my current employer Perm also approved. Is it can be directly filed EB3 or like later later you can file EB2 as well?
So you have a prior approved EB3, and your new employer, you said where's the process with the new employer?
Perm approved and about to file I-140.
Perm is approved though.
Yeah, about to file I-140.
So that's the key on it. Do you already have a receipt for the I-140?
No, they are about to file, it seems so.
Oh, I think I probably would, if they have the perm approved with the new employer, I think I probably would just hang on to filing the I-140 and just file everything together with the adjustment application.
Yeah, can they do this? Can they just, if let's say perm is ready, if they want to have EB2, EB3, both the dates, can they just file two I-140s parallelly along with the I-485?
Well, if this case, did he say he was eligible for EB2 as well? Because I thought he had said
yes, that's a EB2 perm, he said.
Oh, yeah, you can do that. You can file two I-140s associated with the same perm.
That's good. Our next caller, Ram, ending 9799. Ram, ending 9799. You're on the air.
Yeah. Hi. Can you hear me? Actually.
Yes. Go ahead. Yes. Go ahead.
Yeah, so I have two questions. So basically, like I have my EB2 I140 approved with my previous employer, and that date is current. Mine is March 2011, and I'm planning to apply I485 if my previous employer agrees. My question is, my current employer also processing my GC, and we are going to file in next 2 weeks. My question is, when I485 with the previous employer is pending for 180 days, I'm not sure at this point whether I'm going to that employer or not within these 6 months. But let's say if I'm not going there, after 180 days, what happens? Like, can I actually file 485J and transfer it to my current employer?
Right. So if you file the adjustment, if you have an I-140 that has a priority date before, from 2011, and that makes you eligible in the EB2 without having to do any downgrading, you just file an adjustment based on that. First of all, you file the adjustment, not your employer. You own the adjustment, not your employer. They own the I-140, but the employee owns the adjustment. So you're ultimately in control of that application, and you don't need their permission to file an adjustment if you have that I-140.
Q&A session is over. Goodbye.
I should still be able to answer, hopefully, right?
Yes.
Okay.
Yeah.
So on that, hopefully she's listening on Facebook still. But so that being the case, I think that the 204J gives you the protection to be able to ultimately adjust with the new employer after it's been pending for 6 months on there. I think that was what the question is. They're not going to approve this adjustment application before 6 months. So you will be eligible under 204J with the supplement J form that you're going to submit, showing that the new job is the same or similar. So I think that should work, what you're trying to do, if I understood the question correctly. Hopefully I did. But it's yeah, I mean, as long as as long as the jobs are similar and as long as the adjustment's pending for more than 6 months. I'm also assuming that you're allowed to file an adjustment off that old application. It still depends on the job offer being available for the employer. So that's something that that I'm not real clear from the question whether that was the case or not.
Yeah, I think we are end of the time. Thanks a lot, Greg. I know it was very long. It was so exhausting for you, but we really appreciate all the time you have taken for us and helping the community by patiently answering all the questions.
Hope I was helpful.
So long with it.
You guys gave me some tough questions, so I'm going to have to do a little more research on a few things.
Do you want to conclude with anything? What do you suggest? What people should do and be take care?
Yeah, I mean, I think you should reach out to your lawyer over the next day or two and figure out, first of all, whether you're eligible for downgrading and all that, and have that discussion with them, because they need a couple of weeks probably to get their act together to get all these petitions filed. So some lawyers I know are going to be cutting people off if they, like, for example, it comes like the 15th or 20th of the month, and the person hasn't started getting them any of the documentation or anything. They're going to start imposing deadlines on clients to get them things. So that's why you guys need to move pretty quickly in order to make sure that the lawyers have enough time. And also monitor either your Facebook group or lawyers blog on this fee stuff that's changing over the next couple of days, because that's going to potentially screw all this up.
Yep. Thanks again. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Thanks, Greg, again for your timing and helping the community by patiently answering everything. This is Ranjit signing off.